besides this is obviously going to be, if you want to know what really happened, you need to watch this. This is the only place you're going to get this type of interview or
I don't really know what this is, but I didn't do it. I'm innocent, Judge. I'm not guilty. I'm innocent.
We, the jury, being duly impaneled and sworn, find the defendant, Matthew L. Moore, not guilty of murder, as he stands charged in count 1 of the indictment.
Elvis has left the building. It's done. Over. Yo, how we doing? Lovely to see Sarah P here. Welcome everyone. Well, she's not here, but you know what I mean. Hey Sarah P. Join the Auto Corner community. Press join to become a member. If you'd like to support the channel, PayPal, buy me coffee, never required, but other ways appreciated. Thank you, my darling. Check out the official Alternate Corner merch store. Yes, I need to put some more merch in, I think. There you go. Hippie Chick was first. Erin Hack got lost by the way of a Welsh vlogger. Did you like the vlog I did yesterday? Did you like the vlog? I'm trying to become a vlogger for Boston. Probably did. Oh, did it? Oh, shit. Oh, no. Did I set it up? Did I set it up wrong, did I? Bollocks. Sorry, apologies. Hey, Deb. Did you see dragons? Hey, Toots, how you doing, darling? Hey, Hot Mama. Hey, Lorna. Hey, everyone. To the last trial. It has so many similarities, you will be flawed. Hackstar. Deb. Sarah P. She's here, everyone. Everyone's favourite. We know. Apart from me, obviously, but everyone else's favourite.
Sarah P. Sarah P. Sarah P. 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 Sarah P. Sarah P. Sarah P. is lovely.
There you go. Hey, Dana, how's the walking going, sir? How's the walking going, bud? Hey, Sarah. Good afternoon, David. How are you? How is Merthyr? I've not seen you. I don't think I've seen you since the last trial. Hope you're doing well. Don't forget to smash a like, please, people. Yes, please, people. Morning, Dana and Druid. That's not the Druid. That is another David. That's another David for you. This David from Merthyr. The Druid from Mid England. Rhode Island's a fire, Erin. There you go, dancing away. Hey, Eggleston, I was talking about you this morning. I was speaking about you, saying I've not seen Kelly Eggleston for ages, well, not ages, but a few days, and she's always the first one in chat. So nice to see you, my darling. Thank God we're back, Sarah. I have had to be the boss. I'm officially retired. Love it, love it. Good morning to you, beautifully appropriate. Hope you're feeling okay today, my darling. Hope you have an okay day. If not a great day, then an okay day. There you go. Everyone's excited to see Sarah P back. Heather, how are you, my darling? Nice to see you. Nice. Hey chat, it doesn't transport me to hear what happened. My fault. I think I put in the wrong bloody link, I think. She did. Having some trouble today, getting steps today, working as a corporate. It's fine. This is why we did it as a whole figure, Dana. That's why we did it as a whole figure. So even if you don't hit it today, you've got the rest of the week to catch up on it. Like you did 1,000 extra yesterday. Just look at it that way. You only need to do 74,400. So doesn't matter, Dana. You don't have to do 12,500 every single day. Do you know what I mean? Sorry, I don't have my readers on. Morning, David E. Jones. Good morning to you, LPH Picks. Hello to you, my darling. How are you? Sarah, I've been driving him nuts. You all drive me nuts. Welcome back. Hey, Crystal. It sent me to the vlog, but I couldn't hear you talk. There was me. That's just the intro, Crystal. That's just the intro. I'm like, the intro's like 30 seconds and I'm speaking and pictures and stuff. After that, though, it's back to normal. But there you go, Terry Martins. Hello, Terry. How are you, my darling? Freezing cold in Mass. Whoa. It's freezing cold in most places except for here. Hey, Terry. Sarah, PPP. Murphy's going okay, thanks. Be listening now and again when work hours, but off work today, so I thought I'd drop in the chat. Happy days. Nice to see you, David, as always, my friend. Yeah, Trucker. Robin G. There you go. They're all here. All the good names are here. Happy days. Sorry, apologies for that. Those that joined me from Zachary Hughes. I put the wrong link in. I'm sorry. Oh, snow tonight. No. I don't want to see snow. I've got a spot somewhere. Where's my spot gone? There. Got a spot right there. Annoying me. But anyway, I was just saying, hello, Katie Santos. Hello, my darling. Nice to see you as always. I was just saying, would it not be interesting, right? So those of you not following, there's another case we're following called Zachary Griffith, and some defense attorneys, they try and when you do opening statements, they don't do opening statements at the same time as the prosecutors, the Commonwealth. What they do is they wait until their case in chief and do it. I think that's a great idea. And hello, three-eyed catfish, hello to you. I think that if Mass allows it, because I don't know what Massachusetts allows, I think that Karen Reid's defense should do the same. The reason being is this: because juries, we know juries, they don't listen to closing arguments. So the majority of juries, by the time closing arguments happen, they've already decided they don't listen to closing arguments, but they do listen to opening statements. So by doing opening statements, again, for like half an hour, 45 minutes, whatever they had, can you imagine Llandysul coming out now to give a fucking opening statement before the witnesses? I think that would be impactful. I think, it's at the start, it's less impactful. Doing it now before your case in chief, I think that's great. I might be on my own, I don't know, but I love it when defense attorneys do this, defer until their case in chief. Some people don't like it because they think that you want to give a roadmap right at the start, which I get that as well, but I am Robin G. Don't want to take Erin Hack out a bit, no. But yeah, I love that. And I think it'd be impactful because, as I say, most jurors don't listen to closings. They only listen to what they want to listen to, as in they want to see the roadmap. I'm thinking that to give a roadmap before they go in to give evidence. I think that would be quite impactful. Just my tuppence anyway. You can all disagree with me, and it sounds like probably you all do. But all right, close that then. Oh, why has it done that? What was the other thing? I've not covered it. Have you all watched the Juror? You all probably watched the Juror with TV. Great work by Littleboy Aidan. Shout out to him. That was a great get for him with that Juror. But it's pretty much everything we've been saying, or in my stream we've been saying. Now he's a cult leader. walking cult. You know, I for weeks now, well, for months, but for weeks now, I've been saying that Karen should pay for a body language expert to view the jury. And I think I'm right. And I think I was proven right by that juror, because everyone seems to be shocked that this juror said the stuff he said. I'm not shocked. Well, I'm shocked with a few things he said, but I'm not shocked because these are jurors. This is what they do. Do you know what I mean? So I generally think that they should invest in a body language expert, because view the jury. The jury are most important people there. I think that proves it. That juror proves it. I think a lot of people that don't watch trials were shocked with his interview. As I say, I was a little bit shocked with some of his answers, but I was not shocked at all with how stupid some of the answers were. Not stupid, because respect to him for coming up forward. I have zero hate for him. Look, it is what it is. These are jurors. They don't see all the evidence, and they come up with stupid reasons why they vote guilty and not guilty. I watched the jury panel yesterday from 4 years ago. There was 2 trials, right? The first trial was a mistrial, and second trial, the defendant was found guilty, and they came together for like a panel for them, and 3 of them had voted guilty in the second trial, and 1 of them had voted not guilty in the first trial. And the person that voted not guilty for the mistrial was shocked that they convicted them, this woman, in the second trial. And she was asking them about, what did you think of the phone call, the police interviews, and this and that. And the 3 that had done the second trial, like what phone interviews, what police interviews, what they had no clue. They never played it. The defense never played half their testimony in the second trial. And the one woman was there saying, and virtually crying, go, yeah, I said yes, but I'm not sure if she was actually guilty. But I still said guilty. But I to this day, I still don't know if she actually did it. I'm just like, motherfucker, these people. Do you know what I mean? These fucking people. So people are now dissected and saying, oh, we got to do stuff for this juror and what. No, the defense need to carry on as they are. They need to do what they were doing. They just need to fine-tune. They do. Because what people need to remember is that Ronnie guy, he's not on the jury next time. We're going to have 12 different people on the jury next time. So those 12 might be completely different again. So next time, as I say, this is why I bang on about it. I banged on for months. They need to get an expert for jury, for body language. They need to get somebody in for that. They don't need all these other experts. That's something they need. They need something. They need to understand how the jury are feeling about all the attorneys and all the stories and all the evidence and all that malarkey, because it's just too important. I don't think they need to change much of what they're going to do from the first trial to the second trial. I don't think they need to. They're going to tweak and they're going to develop, but they don't need too much. Because the second jury could be completely different. So let's not change the whole strategy based on this Ronnie guy. Yes, listen to it and be shocked with some of the comments and maybe tone some stuff down, amend some stuff, but the main thing is don't change anything. Add some stuff in, but listen to it, but don't take it as gospel. These guys are the dream team, man. They know what they're doing. They've covered enough trials between them. I just think they need to lay off a little bit with the conspiracy stuff, and outline a little bit more about the Arca stuff, more than anything. I'm not even sure they need to go into the whole dog stuff, just, So yeah, don't let that juror influence. I'm glad he came forward, by the way. I know he's got people be slagging him off and stuff. Grow up, everyone. If you be slagging that juror off, fucking grow up. We need more jurors to step forward. We need more jurors to step forward so we can understand what they think like. It's beneficial, really beneficial. Hang on, there's people in chat here. Hang on. Kiki, hello, Kiki. Been a while, needed a little rest from the current trial. I was overwhelmed. Missed you on the chat. Hope to see you do your visit to USA. Oh, there you go. Where are you from, Kiki? Are you in Massachusetts? If you are, then you'll definitely see me. If you're in Mass, definitely. How do you get time to watch other streamers after streaming with us most of the I don't. I watched the Turtle Boy one, obviously, because, you know, that's in my wheelhouse. Juries are in my wheelhouse. That's what I love trials for. I don't look at trials for legal analysis and stuff like that, but I don't care about that because juries is what make trials. They fascinate me. They're the most important people in the trial. You can have all the legal analysis you want. None of it's out. It's all out the door. The most important people are those 12 people. You got to persuade them, or you got to impact them, influence them, tell them a story and stuff like that. So I had to watch that. I'd watch anything to do with jurors because I want to learn, get into their psyches. I know some people, like Ronnie said some stuff that was wrong, but you got to remember as well, they only have a notepad. They got to write it down. I can't coordinate stuff. I can't write and listen. So I would struggle to get every detail down. This is why at the end, in closings, you just pick like 3 or 4 aspects of what you want to get across and just simplify it. But boom, concentrate. No, nothing fancy. Just concentrate on a few different bits because they're gonna write stuff down wrong. They don't have the benefit of going back, rewinding, and doing all that bollocks like we do. So it's easy for us to judge them. But he had some stuff he said was wrong about Lucky. But I don't blame him because, again, he's trying to listen to the question, listen to the answer, trying to write it down, and they wrote it down wrong. They're human. They're human. So I think that was part of why they didn't like Lucky, which shocked me because I like Lucky. Hey Dave, how you doing, Dave? No, I'm trying to practice this. I'm trying to open it. Lona, hello. Be a leader, not a follower. Absolutely, Lona. That's the best way, isn't it, my darling? Hope you're doing well. Mighty Meat, completely different jury, but someone exactly the same. Juries are trash and complete wildcards. They are wildcards. People underestimate. Dave, he did vote not guilty on. He voted not guilty across the board, Lona. He voted not guilty initially for the second count, but then swapped to guilty, but then came back to not guilty by the end. So he voted not guilty across the board. Obviously, everybody did vote not guilty on 1 and 3. So, but yeah. Or do you mean they did vote not guilty? Yeah. So they're in the right wheelhouse. Hack. Little G is in the house. Where's Little G? I've missed Little G somewhere, yeah? I don't know where Little G is. Oh, hello, Little G. There you are. How are you doing, my Little G? Hope you're doing well, my darling. Been a minute. There you go. There you are. Well, I'll see you in May, Kiki. I'll be around, plenty of stuff doing. So, please come meet up. Absolutely. And they should allow transcripts. Yeah, I mean, this is something they need to look at across the board. I don't think you need to look at transcripts. Well, you do, but look at the streams. There's streams now. Do you know what I mean? Let's look at the streams. If you got a stream there, every courthouse, in my opinion, should be streamed. Every courthouse, and fuck the transcripts. Just rewind the stream. Let them watch the stream. The part that they need to watch. Because I understand why they do transcripts, because it's a lot for the court reporter to get right, because obviously they got to tidy it up and stuff like that. I get that. So let's use the fucking streams then. Do you know what I mean? Gary, hello Gary, how are you, sir? I hope you're well. I'm not seen you for a week or so now. Hope everything's doing. Are you doing okay, my friend? Hope you're doing well. I don't see him go live anymore. Who's that? Oh, Mighty Meat, yeah. Mighty Meat's been banned, I think, from YouTube now. Hello to you, Daffodil. We miss you too as well, my darling. Still thinking of you, Daffy. Still thinking of you, Daffy. Mini meat. Oh, he's in YouTube jail, is he? I need to start streaming on Rumble as well. I'm going to do YouTube and Rumble. That's what I need to start doing both of them as well. So, try to keep an eye on this stream as well, because Boston 25 normally goes live, don't they? No, what I mean is, if there's no, I agree that they shouldn't have it for everything. I think you would have to have specific reasons, do you know what I mean, to do certain things. Like you're talking, or you could limit it to like 3 things a trial or something. I wouldn't want to do it for everything. You're right, because it gets too much. But yeah, Judy got bored and stopped listening. Yeah, it's supposed to be shorter this time though. It should be shorter this time, hopefully. So. Yeah, well, I've got a strike now, pricks. So I might be joining you. Yeah, it might be Rumble exclusive myself in a little bit. All right, it's great because when someone new comes in, they get to see me and Dana naked, topless. I try to keep Boston 25 normally have it on before most people, don't they? No. What's this one then? Oh, okay. That's a different case. I'll put it up because I know some of you screaming. I just see your message, Crystal. I can't put it up at the minute, but congratulations again to Crystal. She's engaged now. Hang on, maybe I can't put it up. I need to put it. Hang on. For whatever reason, it keeps freezing. Oh, here you go. I got one here. Right. Hang on. I got one here. This is Crystal. She got engaged to Rob on the weekend. So congratulations to you, Crystal and Rob. There you go. I can go that. Oh, you see, you fucking. Hang on. And that's the ring. There you go. There you go. So again, congratulations to you. Right. I'll get a Law and Crime stream up, but it's normally you all normally shout to me and say Boston 25. So I'm trying to keep an eye out, but so today be interesting. I wonder if they're going to change any more dates or anything. Do you think that they're going to be like? Do you actually think there'll be a trial? Let's put a fucking poll up then. Let's put a poll up. Start a poll. Oh, Gary, thank you. Do you think there will be a trial on the 1st of April? Thank you, Gary, and congratulations to, hang on once I see it, congratulations to Crafty Cow, Forest Dump, Mama Ames, Linda Mitchell, Just Irish, October Girl, Laura, HH, Ariel, Donna Lynch. There you go. Thank you, everybody. Thank you, Gary, for that. I'll put your thing up here. Thank you, my friend. I appreciate you for that. Thank you. That's really generous of Gary. Coming back and then he gives 10 memberships. Happy days. I even got a video taken down and it's spent. But I think you're better on Rumble. I might be, as I say, I might be joining you, sir. Right. Mexi's in the house, everybody, so that's fine. Mexi, you can behave because Sarah P's back, so we all know what that means. You've got to behave now. There you go. They arrived at court at the Kiki. Happy days. They'll be coming in. Where's this gone now? Hang on. Pull that in. I'll just do this. Shout as well. Resist the silence tonight. Dina is on tonight. So make sure you watch that with Dina tonight. That'll be a cracking episode. She's a cracker. Firecracker, Dina is. So there you go. So they must be coming to court then if they've just arrived. Happy days are here again. Happy days here again. What's the other one? Boston 25, isn't it? You guys keep saying. Let me put Boston 25 in there. Boston 25. Right, I got that. They're not live yet, so I'll keep an eye on that then to see if they are live. Shout to me. You know the score. You know the drill. And if we miss 5 seconds, 10 seconds, people, calm your tits. It's all good. Don't have to worry about it. It's all good. Oh. Right, what's the poll saying? Oh, 50-50. 22 votes. Oh, no, a bit more than that. 24 votes. Do you think there will be a trial on the 1st of April? Yes, 54%. No, 46%. So 50-50 pretty much. 50-50. That's interesting. I think they will. I think I worded it badly, Josie. I worded it badly. There's definitely going to be a trial. But it's more of a will it be happening on the 1st or will they push it on? Some people think they're going to push it on. I don't. I think it's going to happen on the 1st. I think Canoni wants it to happen. She wants it off her record. Also, you know, that juror thing. Yeah, my bad. Thank you, Kiki. Thank you, Kiki. That juror Ronnie, you know, as I say, you got to try the trial as you want to try it. But there was some good insights there for both the defense and the Commonwealth. To be fair, not just the defense. I think the Commonwealth got a lot out of it as well. I know LPH picks. I know. So the hearing today, I'm not 100% sure, but there was a Dorber hearings, I think, were lined up, but I don't actually know what they're going to do today. Bev stays drunk. Yeah. April Fool's Day would be quite the. Yeah, do you know what? So the 1st of April will be when they start the jury selection, and she said in the last hearing, I believe, that they've already got 350 jury pool lined up for each day from the 1st of April. They've already got lined up. So that means she's cracking ahead with it. She doesn't give a shite. But the defense have to go through all this rigmarole. even though they know she's not going to dismiss anything. It's because for appellate issues, so if Karen did get found guilty of anything, they've got to show that they've done all these things every step of the way correctly. Bev is never going to, Stacey says Bev is never going to dismiss this. Commonwealth is never going to drop charges. That would mean the state would have to admit they were wrong. Never happened. I agree. It's pathetic. Like, they have the same information as the defense. Like the ARCA guys, that should be enough to dismiss this case. Full stop. It should be enough to dismiss it. But no, we're going ahead with it. I mean, look, it's in Massachusetts. I don't want to pick on Massachusetts, or how do you say it? Massachusetts. Like, how the hell does a woman shouting at a man and him getting a heart attack, how does she go in front of Judge Bev? How is she, like, what? So even though you think this is bad, imagine being the woman that got arrested for murder or manslaughter, whatever it was, manslaughter, for shouting at your husband and he gets a heart attack. It's like, what the fuck? So there's something wrong, Jimmy. There's something wrong in the neighborhood. Who are you going to call? Ghostbusters. No way in hell the jury pools are reliable. Everyone knows about this shit show. They will never get a fair trial in fair jury mass at this point. No, I agree. They're never going to get a jury that 100% don't know anything about this case. The scary part is, what are they, I don't like it. Massachusetts. It's everywhere. Who are you going to call? Definitely not Canton Police. Don't. Well, look at Kevin. We spoke about, Dana told the story about Kevin, one of the first people that were out there standing for Karen Reid, him and his wife and a couple of others. Kevin broke his hip, right? And he doesn't trust the fire and the ambulance. So he got a friend of his to drive him to hospital because he doesn't trust the Canton Calvary, or whatever you call them. So it's bad. Ghostbusters Mexi would be better. It's insanity, and I feel sorry for you guys. Like the people of Canton, we don't understand. Not just Canton, sorry, Massachusetts, I should say. We don't get it. We're judgmental right now. It's everywhere, obviously, but you got like a magnifying glass on you guys. So I just, like, once I heard about that manslaughter case, a woman shouting at her husband, and I mean, all you women should be scared then, because I'm sure all of you fucking scream at your husbands. So, cheapers. KD, hello, my darling. Nice to see you. Sean's still around to be. No, Sean's doing a little bit on this case, but he's moved on to other cases. He's got a project he's working on, I believe. So he's not as involved in this case now. I know he's busy with something else, I think. I'm good. Dylan, I watched your walking vlog and I gave you motivation. So, do you know what? There's about 4 or 5 people who said that now, KD, about inspiring. Thank you so much. I love it. I went out today. All I'll say is, people, be careful, because I got a sore ass now and I'm fucking stiff as they come. Like, literally, I'm walking like a duck. Talk like a duck, walk like a duck, must be a duck. I can't walk. But I did it again today, so I'll put some stuff together end of the week and put another vlog up. Mr. O, nice to see you, Mr. O. Lovely to see you. How are you doing? I'm doing all right, thank you. How are you, sir? Hope you're well. Here we go. Aaron, no, I'm going to use talc now. Hippie Chick told me to use talc. I think it was Hippie Chick. So I'll do that. Robin, yeah, I do. I just go straight into it. Like today, I did circuit training for an hour and then walked 3.1 miles straight after it. Never again. My feet are hurting. Everything's hurting. I got muscles in places hurting like they never knew could hurt. So, right. Buy your freeze. I need something. Right, let's have another look then, see if there's anything. It's nearly 11 o'clock, so let's have a look here. I am, Mr. O. Mr. O, are you in Massachusetts? I hope. I hope you're there, Mr. O. If you are, then we'll definitely meeting up. I'll be in a few different spots, so yes, watch your space, Mr. O. I will be there. Toots, I don't, Toots. I'll be honest with you, I don't. That's part of the problem, Toots. I don't, Crystal, if I'm being honest. Is Will there, maybe? Robin G? I do need to get better shoes, that's for sure. Magnesium spray, never heard of that before. So, Mr. O, if you're a mass, let me know. We'll definitely be meeting up with people. Hang on then, let me go live. Karen Reed. Oh, okay, Court TV is live, so let's go to Court TV. Let's go to Court TV. Just a reminder, I don't speak over the trial, or I do not rewind and stuff like that, so please don't ask any of that stuff, because I won't be doing it. So here we go, we'll do Court TV then. But yeah, I mean, after it's all done, we might go back and watch some stuff, but for now, we're not, I don't pause in stuff. I admire Ronnie's courage to talk about his experience as juror. When I was juror on there, where the trial was completely overwhelmed, I could not imagine I have to sit through the ball. I totally agree with you, Kiki. I so much respect for him. Obviously, we all differ with, and our minds are like, what? They didn't get this, they didn't get. But it's important because he's a juror, so they're not perfect. And also, anyone dissing Ronnie needs to be shot, because we need more jurors to come forward. It doesn't matter how much we disagree with their feelings and their theories and stuff. We just need them to come forward, because lawyers, like excellent lawyers, like the Dream Team, Yannetti, Little, Bedrow now, Jackson, all them, they're all gonna take that and be able to analyze it, and it's only going to help people in the future. So I want more and more jurors to step forward. It doesn't matter if we agree with what they said. They will never get it perfect, because they're human beings, and they don't get the opportunity to go back and forward and do all that malarkey. They just don't. So yeah, praise to him. Don't have to agree with all this stuff he says. Some of his stuff, I'm sure, was infuriating to listen to, but he spoke the truth. So yeah, Gary, not gonna lie, Dylan, I watched your walking vlog and it made me knackered watching it. But all jokes aside, keep up. Thank you, mate. I made my workout weights out. There you go. That's all I want. Is people saying that they're working out now because of me. Happy days. Happy days. And obviously, and Dana as well. Thank you to Dana for being a part of this as well. Even though I'm sure he's cheating. He's listening right now. Let me put my headphones on then. Oh, they're in court. You can hear them in court. There's movement. I said, Dana, I think that you put your phone into Tracy's handbag and let her walk around for like 6,000 steps. And then you take it out of the handbag and go, oh, I'm just going to walk a few more miles. I'm joking. Oh, also, right, before they come back, right, what's your thoughts on this? Right, I'm intrigued to hear your thoughts. I got thoughts on this, right? So I hear your thoughts as well. Hang on. So most of you think it will happen on the 1st of April. Happy days. Dave, it's not quite as easy as you're making it out to be, Dave. I'm too unfit to do it. Let's put this poll up then. Hang on. I'm intrigued to see what you would do. I know what I would do. Hang on. Kiki, there's a link, there's a vlog thing it is, so hang on. Oh, what's it called? Okay. I don't have a Peloton, Kelly. I wish I did. Right.
All persons have any business before the Honorable Beverly Cody, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated.
Judge 22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the
Good
Commonwealth.
morning, Ms. McLaughlin.
Adam Island for the Commonwealth. Good morning,
Good
Your Honor.
morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right, I was told counsel wanted to see me at sidebar.
Briefly, Judge.
Okay. Oh, they go sidebar straight away. Sidebar. Right. That's a great team. Obviously, Bedro as well. Good. So I only ask about this, right? I would personally move to a bigger courtroom. Personally, I would move to the bigger courtroom if I was Karen, because after listening to that juror, the impact they wanted on the witness stands didn't come across. So now I'm like, let's make it bigger. Let's make it so that Paul can't give daggers to Karen. Also, the jury currently are looking directly at the Keefe family. Let's move that around a little bit so they can't do that anymore. Bigger's always better. Well, no, it's what you do with it, Gary, I think. That's what ladies say. Phone call from Hull. I won't answer that. I just generally think that we should have a bigger courtroom. I think it'd be better for Karen not to have. Look at that. Paul's right in front of her. He will be looking at her throughout of it. Let's give her space. Hang on.
All right, so what I'd like to do is start with, now I don't know if you all have the paper numbers on these. You probably do if you've been looking at Mass Court. So Commonwealth's motion for records, WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
Good morning again, Your Honor.
Good morning.
I spoke to Mr. Albano last week and again last night.
Okay.
And on behalf of Fox, Boston 25, they're agreeing to my motion in its entirety. They've asked for the courtesy if I could wait until March 1st to receive all of the information. I expect they'll file it with the court.
Okay.
And so with the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay. All right, I will. So March 1st before they can get it here? Was that the
Yes, they
date you
They'll
said?
have it on or before March 1st.
Okay. All right, so that motion is allowed by agreement, and the order is right here, Mr. Clerk. All right. Next, I did amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do that, right? On the 10th of February?
Yes, Your Honor.
Okay. All right. So paper number 483. This is the motion to compel production of a forensically signed copy of the January 29, 2020 video surveillance footage in law enforcement custody. And the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition in response. Do you have a paper number? Okay.
I'm sorry, the opposition.
Defendant's motion to compel production of a forensically sound copy. We'll get started in the argument, and you can give me that.
506,
Great, thank you.
that's the response.
Right. Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions, meeting with Mr. Brennan after court, the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present if all the information was a download from some iCloud account, unnamed iCloud account. As long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We were predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, etc. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan. And it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer's or a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little sent an email saying, I'm confused. now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there. And then it was that same day that miraculously the Canton Police Department revealed that, in fact, it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information, it's exculpatory information. The audit trail is also Brady and exculpatory, because the audit trail will tell us information that we won't otherwise have from the raw video. How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files. The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that, because we would think that in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it. I'll submit.
Mr. Brennan.
It seems like another effort to portray some type of injustice wrought upon the defense, that half the facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there, and why would they be 3 years later? And after they filed a motion making representations that weren't accurate, I no longer had the confidence to have off-the-record agreements with the defense. They have has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I will always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process. And I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petro, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When the government would ask, or state police would ask for a download of a particular event, like the Sallyport area, he would download it. And what he told me is that that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive. But I called the defense, not only due diligence, professional courtesy, to say, you are already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy. After you asked us to speak in the back room, the 6 of us were there. We had a conversation. We said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also it seems if it's on videotape, it can limit baseless allegations later. So we were happy to do it. And then when we got back to the office, the request changed. Under the spirit of Brady violations and due process, it was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually know exactly what they're looking for. It is a simple click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay has been because they've asked for all these different accommodations and different styles of doing it. And so we want to meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
How quickly can you do that?
I imagine we could do it one day, but today is, we have done by the end of the week.
You want to maybe, I'd be heard briefly,
Yes,
very, very briefly.
take your time.
Thank you. Mr. Brennan's confidence notwithstanding, I don't know what to say about that, pretty immaterial, what his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth. And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on, this is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata. Euphemistically, it's called electronic fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server, every one of them have metadata on it. So it's not difficult. We're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more video. Happens to be an inverted video. Where did that one come from? Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want
That
the
October 24th, did that video come with the metadata?
No, it's just video. It's a video file. And I'll also, that's a great point, Judge. When you have a hard drive that's storing video files, my understanding, again, I'm no expert. My understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to play the video or to store the video. It'll also have potentially some sort of video player, maybe a proprietary player on it, and then there's going to be the file. So that's what we're asking for. Let's get the metadata associated with all those things. It's not a hard ask, it's not a heavy lift. There's no reason to justify, well, you know what, I'm just going to drag and drop this and you get the video and nothing associated with the video. That's all we're asking.
Any further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact, historically, if we look back, we invited them to come to the actual hard drive and do it themselves, and they declined. So this isn't an issue where the government is trying to hide something or keep something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can accommodate. If they want to come, they're invited. If the court wants me to inquire of a retired sergeant detective about metadata, I'll do that. But the issue is going to become that when we drag and click these videos, and if there is no metadata or logs or what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty. Our duty is to provide the videos. What more can we do than to invite the defense themselves to come into the Canton Police Department and take a look at the system? So if there's something they want, then we'll copy it for them.
Okay. Thank you very much. All right, Ms. Giannetti, the next one should be fairly quick and simple. The motion for Pro Hac Vici. I asked you before when Mr. Alessi joined us, you have a rather vague good cause exists to grant this motion because Mr. Betterow, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last time what you mean by that.
Right.
I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
Understood. And would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Okay, thank you.
it's rare. All right, but I need a more detailed affidavit.
Your Honor, may I have just a moment with counsel? Thank you, Your Honor.
Okay, the next one's paper.
May I be heard briefly?
Yes,
May I be heard briefly?
yes, yes. So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay,
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right. And I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Betterow is also an attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case. Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Betterow is representing him for. Now, it's not great clarity, but it's been represented that there is a relationship between Mr. Betterow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys in this case. There's a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Betterow, Mr. Bradel, have an understanding with the defense attorneys in this case, that there's an ongoing long-term implicit mutual assistance and mutual defense that they've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is curious that that relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about, in a sanctions motion, a violation, a direct violation of protective orders in this case. And the discovery in this case was provided to special attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery, and much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage. And I am worried, and I have good reason to be worried, about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses. And this information, if a court order won't protect it, then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each. And so, not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government. And so while I do not object to Attorney Betterow, they should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Betterow presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse. And that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial. And the witnesses are entitled to walk in this courtroom without being abused. Thank you.
Okay. Ms. Giannetti, I have to consider everything that was just said, but I'll wait for your affidavit.
Right. We'll try to address those issues in the affidavit, Judge. Thank you.
Okay. All right, the next one I believe is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of Gretchen Voss and or Metro Corp. Relatively straightforward, but I'll hear you, Mr. Brennan.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay, there's no objection to this, is there?
No, Your Honor.
Of course, I'll provide the defense a copy if they want.
Yes. All right, so this is allowed. All right, so the next is paper 490, Defendants Rule 14 and 17, motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from attorney Mark Diller on behalf of the O'Keefe family in response to Defendants Rule 14 and 17 motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Ave in Canton to conduct independent testing and analysis. I assume counsel has seen this affidavit of Mr. Diller?
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today, and today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us, and I would ask that the court take no action on this motion until we've had a chance to view them, and we may not need to have action on this motion.
Okay. I do just want to say it's clear from this affidavit that there's the spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested.
Understood.
Okay. All right, so no action taken. So the next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay, I'll hear you.
Would you like me to address both issues first or?
Both issues.
Okay. So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses. And that's what we're asking the court to reconsider. It is our position, Judge, that, part of, and I believe I quoted a case on the last page of the motion, the effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outline in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to, Ms. McCabe, it was never mentioned anywhere that she spent an hour at the home, the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data, which revealed that meeting did take place. And so, the Commonwealth, armed with that information, went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. And secondly, with regard to the juvenile witness, as the court remembers, I'm sure from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident, which, we question what was done behind the scenes to, arrive at that conclusion as well. And I also, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed. So I take responsibility for everything that's in there. But, we also make the point that with regard to, Trooper Proctor, it appears as though there was, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument. And he obviously uses derogatory language toward him as well. If we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but this is I won't say unique trial, but it's a rare trial that, is streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with. And to the extent that we turn over this impeachment material and the Commonwealth uses it, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging on cross-examination. So switching to the Commonwealth's motion for sanctions.
You know what, let's wait. When I said both, I thought you meant 2 points that you made up to.
Understood.
All right, so, Mr. Brennan?
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations. And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes there are names on them, talking about theories of the case. I give it to the defense because it's in my possession, custody, or control. I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides, and that should not change. It's going to create chaos. It's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, it'll be abided by.
Okay. Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. No, the only thing I would point out, Your Honor, is that with regard to the report of Jennifer McCabe, I should say, revealing this link meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best, and I will continue to provide all discovery timely to the defense.
Thank you.
I've been on the side where late discovery comes in a trial. And I never want that to happen. Sometimes exceptions happen on both sides, but that is not the intent of the Commonwealth. The Commonwealth is doing everything possible to give the defense more discovery than they're entitled to as early as we can.
All right, thank you. Next is paper 495. This is defendant's motion to compel discovery, and then there was a response from the Commonwealth. Paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Your Honor, we filed a motion to compel certain discovery that is still outstanding. There's 10 items. I'll address those in turn. The first request deals with...
So you have the Commonwealth's response, right?
Yes.
Where it doesn't object to some. Are you going to skip over those? Or?
Yes, of course,
Okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions. One before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage. Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have video surveillance footage from outside the Canton Police Department, where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those 3 productions, or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if that's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State Police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos. But that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore. There's certain names that this court will recognize. First responding officer, Sergeant Lank. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper Garino. Lieutenant Brian Tully. Trooper Kathleen Prince. And Norfolk County District Attorney Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically, in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again, deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore. No evidence of improper conduct, nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants, affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was in a cadet in the Stoughton Explorers program. They detail violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects. As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So if it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right. If somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right. Mr. Brennan.
It's important to represent facts accurately. And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked for chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety. There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to then now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case, troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it, a factual basis, a good faith basis. We hear the defense say that Trooper Garino says, nothing to see here. I have not seen that report where Trooper Garino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Garino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Ms. Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why? Why that case? Troopers work on many cases. That case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case? Nothing. But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor. Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady v. Maryland in Giglio, and most recently set out in McFarland and Graham, the Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth v. Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024. Please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material. The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue to abide by our obligation and duty. Number 6 and 7, we do not object. Number 8, there is a difference between ARCA, and we'll discuss that in more detail when we get to the ARCA motion, and expert discovery. We have provided, there is a difference between ARCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCA, and again, I'll delve into that when we talk about ARCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week, and I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right. So I'll take that under advisement. Do you have that Rule 17 paper number?
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're over 500 at this point, so.
Yes.
All right. All right, so next we'll move on to the so-called ARCA motion, Commonwealth's motion to exclude employees of ARCA, paper 497, and the opposition 505. So, Mr. Brennan? Sure.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer That's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded, objective witness says, So not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before the response.
Court, all right, please. It's a piece of fucking work. Like, talk about bias and all this. What about your witnesses? How biased were your witnesses? Brennan or Lally at the time? Motherfucker. They're full of shit. They what do you call it? The Lally showed everybody the fucking, like, Gemma Cave, all the transcript, like, this is what's going to come up. This is what, I think they're going after the ARCA guys. Like, I mean, she is pissed, Robin. She is pissed. She, you know, like, I'll be honest with you, if this is, like, dated properly, Jackson's in a bit of trouble here. Because Jackson said he had no correspondence. So, you know, obviously he had a little bit. I don't think it was that bad or anything, but he had a little bit of correspondence. Oopsies. But yeah, she's gone for a break. He's a piece of work. Let me just tell you, massive piece of work. It's not the reaching out bit, Robin. It's the commentary around it. The commentary of, you know, basically, if we agree with you, Gwyvodaya, blah blah blah. So it's not about. She told him to reach out in order to get the testimony separated, because it was, at the time, I think it was 3 of them. Dice it up to who's doing what. But then obviously they went a bit further than that. She just bounced. Yeah, she's pissed. She's pissed, so she bounced. It'd probably be about 10 minutes, 15 minutes, I think, little G. And that's interesting. What payment would the defense offer them? I didn't get that bit. I don't understand that bit, if I'm being honest. So, yeah, Jackson was supposed to reach out. He did obviously reach out, and they were supposed to split it because it wasn't clear who. So Lali's point was in the original trial, it wasn't clear who was going to be speaking about what in the report, and he was supposed to reach out to ask them, can you split it so we know who is speaking on what during trial, because it's not very clear. That was a request. I suppose I don't think it was that bad or anything, but then I don't know. He also said that the correspondence wasn't dated. So those could be new and after the last trial. Yeah, that's true. I don't think so, but yeah, that could be true. That could be true. I think Wolf went a bit further than just saying what they're going to talk about. And I'm trying to call it a buck. Like that wasn't like that is. If that was a Commonwealth that did that, we'd be up in arms. So I don't think it's that bad, but I don't think he was like, I don't know. But we'll see what she comes back with. But also, like Katie says, we don't know when the time was for these as well. I mean, I'm guessing we do know, but there could be other correspondence that we are not aware of time-wise. So Jackson can clarify that, or the SC, whoever is actually going to take this paper on. Fucking stiff as fuck. I think if it was just that, Mexi, I think it was more the some of the commentary stuff. Again, I don't think it's that bad. Wherever it is. The only thing I was interested in was the money bit of it. Why would they talk about that? I don't know. We'll see. She might not even be pissed. She seemed pissed because she abruptly ended. But she might not even be pissed. I don't see what she can be that pissed about, to be fair. I mean, okay, a little bit maybe, but not that much. It could be the travel expenses, could well be. Until they respond, we don't know. We've got to wait till respond. Like, as we always say, people, there's two sides to every story. So we'll see what happens afterwards. It keeps getting dusty on this one. But as I say, we're not even, like, it seems that she's pissed off, but she may not well be pissed off. I don't know. It's Bev, isn't it? You just don't know with her what she's thinking of doing. Just go with the flow with it. But if she is pissed, she's obviously going to let them know that. I just look at the courtroom as well. You know, you see, this is why I want a bigger courtroom, because I don't like the O'Keefe family so Nia next to her. Oh, I don't know. This fan is going to be an absolute nightmare. Is the audio working all right for everybody? Because I don't think it's that loud personally, but I am deaf in my left ear, so maybe not. Bigger room, jury can't see witness faces. To be quite honest with you, in the first trial, I was like, I wanted them to see the faces, but after the juror spoke about it, I was like, yeah, we didn't really care. Also, because they're all down writing notes, I don't think it matters. I care more about Karen now for the second trial. So first trial, I agree it should be in a small room, but now I'm like, I don't care about the witnesses' faces. This is just my thing. I don't really care about it because I'd rather Karen not having to face the O'Keefe family, and also I'd rather not have the jury, because of the jury, we know for a fact, Jesse Machado used to tell us all the time how the jury were very receptive to Mrs. O'Keefe, crying all the time, and they were facing her. So I think you just take them behind so they don't have to look at the crying and stuff like that. I don't know. Screen might be an idea. Yeah, it might be. I don't think people would look. I don't know. Some people will, obviously, but I don't know. But also, I think it was a case of 4 jurors can't see, so possibly it would be a case of the alternates. You all go down that side, and then try and get the jury in different way. I don't know. But I don't know. I'm just going by what I see. As I say, my preference would be to protect Karen a little bit more. Why won't this open now then? But as I say, the first trial, I definitely was in the camp of let's see their faces, let's see their faces. But then after seeing how slimy the McCabe's were, or the McAlberts, they were smiling to them, they were nodding, they were talking to the jury. I'd rather not have them face it. And also, you got bigger support in there then for Karen. I'd love to see more people in there for Karen as well. I think you can see them, Lorna. I think it's only like 2 people that can't see you, Lorna, so you would be able to see the faces. You would be, but I don't think they would look at. I think it's different if it was a trial with no notebooks, but there's notebooks and stuff like that. I'd rather they didn't look at faces and wrote down information, like some people do. Like, so every time you're looking at a witness, you're not writing stuff down, basically. So I'd rather people not look at the witnesses and just write stuff down personally. But again, there's no right or wrong to it. We're all different. But having heard the juror, what he had to say, and I think feedback from the media and stuff like that about how they were influenced by Mrs. McCabe crying and stuff like that. I just don't want Mrs. McCabe, not Mrs. McCabe, sorry, Mrs. O'Keefe in front of the jury. I'd rather she was to the side, so the jury, it's less likely that you can get the jury to, to see her crying. Because, as Jessica said, there's about 3-4 of the jury that were very impacted by her crying. That says a lot. So that to me was probably 3 or 4 guilty people right there, just based on emotions. So you do need 12 to acquit, but that's what I mean. But again, look, we're disagreeing, Lorna. You know, you and me disagreeing about how we want stuff done. You know, it's really hard to get 12 people to agree on anything. Do you know what I mean? So it's little factors. I'm not saying I'm right by saying this personally, but going by what that juror said and going by my personal preference of wanting note takers, I would want a jury full of note takers, not just I don't know. But I was shocked when they said that the McCabe didn't impact them as a juror. See through the jurors didn't impact them. They came across as credible, so I was like, oh fuck, right, okay. So again, there's no right or wrong answer because we've got 12 new people that will be wanting completely different stuff. Do you know what I mean? So again, there is no right or wrong. We can all agree to disagree on stuff. The problem I have sometimes is I've got the mic, so I have to say it. With Lorna, if you had the mic, you'd be saying differently, but I'd be chatting. So I respect everyone's views. We're all different, and that's why I think listening to jurors that are completely different is important. Like that guy, Ronnie, I was like, whoa, that's good. The motion to dismiss would be good, I think. I think the motion to dismiss could be good. And it's super important as well because of obviously the foundations. Yeah, but I'm back. You see that. So I agree with you, David. I think the video stuff. Look, I can't understand why this trial is going ahead. I'll be honest with you. I can't understand it. Not just the video, but everything, David. That guy Brennan said about why they want Sandra Birchman stuff. Well, mofo, we want this stuff because a lot of the key players in that are the key players in this. And look at what the shoddy work they did in Sandra Birchmore. So it has everything to do with this trial. I get annoyed with that. Come on, Bev, get back, get your ass back in, Bev. I want to know more about this stuff with Jackson. And if she actually just wanted to go to the toilet, to the restroom, or if she was actually pissed, we'll be able to tell straight away. What else is on the docket? I don't actually know what else is on the docket. Are they definitely, so the ARCA guys now, are they definitely doing the motion to dismiss today then, Robin? I've not seen, I don't actually know what they're actually talking about today in full. The whole thing around the video is pissing me off. Just get the whole metadata, get everything to the defense. Like, what are we doing? On one hand, Brendan, you're saying that you're not corrupt, that you want a fair trial for her, but then on the other hand, you don't want to pass things over, it seems, or so it seems anyway. Right. And the whole thing with the Turtle Boy as well, that was, well, what is going on? Right, so no. See if there's any updates. Okay. Doesn't seem to be much going on the land of Twitter. Okay, we'll see. Hey, Dennis. How you doing, fella? How we doing, Den? How was it out there? Was it cold out there, Dennis? Thank you, Dennis, for being a warrior out there. Boots on the ground. I hope it wasn't too cold. Hope it wasn't too cold, my friend. You're probably back home now, Dennis, yeah? Freezing, I thought so. It looked... Fair play to you for being out there. That's the side of things that, you know, we don't see, we take for granted now, I think. Thank you for everything you do, Dennis, and everyone else, boots on the ground. Just a shout out, remember tonight, one of the important boots on the ground is Dina. She's on Resisting the Silence tonight, 6:30 Eastern. That'll be a great show. She's a rocket. So home now, just walk the pub, fine. Get your 10,000 steps in, yeah? It's yeah, watch Dina, she's amazing. David, Bedro will be allowed on. It's just more of a restrictions stuff, and you're just making it complicated for no reason. Bedro's legit. Bedro's not, you know, corrupt or anything. He's legit attorney. He knows what his duty is. He knows what oath he took. The way that Brennan describes it, you know. Paul, how are you, Paul? Hey, I saw you in a different pizza joint yesterday, Paul. I think you were in a different pizza joint last night. Hope it went well, Paul. Nice to see you, buddy. Much love to Cynthia, and obviously Dennis. Much love to Brenda. Hey, big guy. He is, Gary. He is. There you go, Paul. Where was that, Paul? I don't know where that was. What location was that at? You just raised a lot of money anyway for Karen. We come back. So, was it what reason? Because I don't remember. Why isn't this trial being moved then? He is, Luna. I think he's great insight. I think he's a great addition. Why was this trial not moved now then? Because at the end of the day, you're never going to get 12 jurors now that are unbiased. You just hope that he was with me. Norwood. Oh, was it a Norwood? Diaper. Oh, I thought it was somewhere else. JJ Grimsby's. I thought so. Dennis, you're confusing me. Dennis, did you go there first or something? Because yeah, I saw Paul in a different one. Karen doesn't want him moved. Okay, that's interesting. Because I'm surprised. That's all. I'm surprised because it's literally impossible to get an unbiased jury now. So, I mean, that could go down bad because you just don't want any of the McCabe's to be in there. He did both. No drinking on the first one. There you go, Paul. There you go. Hang on. Troubles ahead. Hang on. Oh, what an amazing picture. Hang on. Let me do this. Save as. Dana just sent me a picture here. Let me do this then. Oh, sugar. I did something wrong there. Right. No, I have not watched it, Robin. I've watched all the other bits. I've not watched it. I've every intention of watching it. It just haven't had a chance. I was watching some Juror stuff yesterday. I need to watch it. Here they are. This is Norwood. We want to do a trolley ride pub crawl in Boston. Woof. Here we go. Look at this. Some of the Warrior. I did try and download it, but I can't. There you go. Well, so obviously tonight you see this young lady on Resistance to Silence with this monk. I was going to call him monkey, but I can't. This beautiful young lady here and this ass here. I'm joking. I could take a snippet. You're right. I just so 6:30 Eastern. Resisted to Silence. Oh, that's such a nice photo as well. Mr. Sweeney in the middle there as well. Such a nice photo that is. Thank you, Dana. Dana's a speedo man. 25. Whoa. Oh, thanks, Robin. Thanks. Yeah, I'm interested in that then. Dana's a speedo man. Dana's a speedo man. Dana's a speedo. He loves his speedo. Dana's a speedo man. Dana. Judge Beverly Condone is taking arguments under advisement. Yes, the Commonwealth ensuring they are rocking up a big bill as possible for Karen, in the hope the funds run out, in the hope of a plea deal. Wishful thinkers. She'll never plead now. She's gone too far to plead. You know, there you go. Thank you, lovely Sarah P. That's a link for tonight's Resist to Silence stream. She'll never plead now, but you can understand why people do plead, though, yeah? You know, you can understand why innocent people plea. Karen's never going to plea. You know, she's innocent. She's never going to plea. She's gone too far. But you see some innocent people taking pleas because it just, they know. Like, if you don't have a dream team, then, you know, it's hard. Never, ever. AJ and the rest of the team aren't taking payment. There's the controversy on that. I saw something. See you, Paul. Enjoy the finger up the bum. There's controversy on that, Robin, because I saw on Twitter about that, and people said that that's not true. That they have taken payments. They're not doing additional payments. But I do go with you because it's some wording of it, the way they worded it. I've not watched it, so I can't say. There's a debate on it on Twitter that I saw, and the people said, I don't know. I've not seen it, so I can't say. I've not seen it. I'll go with what you have to say. I've not seen it. Just I know there's a debate about it, saying no, that's not what he said. But Carmelo, it'll just take years and years. Do you know what I mean? For her to sue and stuff. It's gonna be hard. Have a good day, Paul. Annual doc appointment. Yeah, that means up the bum. Good luck, my friend. Hope it goes all well for you, Paul, and from Dennis and from Mexi as well. Interesting. Yeah, so you hear about people taking plea deals, because imagine if you've got a public defender. If you're a public defender, like, and you were offered, like, if you're faced in 20 years and you were offered I don't know, a year or something, you know, and you got this public defender, and you're like, oh fuck. I know people always say, "Oh, I'm innocent, so I'll fight it." But I mean, if you just literally have a public defender who's not, I don't know. I can't say one way or the other. It's just scary when you're facing like 20, 30 years in prison. I'm a pussy though, do you know what I mean? So, but then hopefully I would never. I don't know. I'm too stubborn to take a deal, I think. Um, Back of the envelope figures. What's that mean? I don't know what that means. Maybe me being thick. Here we go.
We're back in session. You may be seated. Enjoy. Cell phones off. Put away.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
It would have to be at 9 o'clock in the morning.
Your Honor, if I may hand up the discovery that was
Thank you.
provided by the defendant reference by.
Oh, great, thank you.
Is there any way we should suspend for today?
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th, even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we could do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not.
Ma'am, just a moment.
Yes. Thank you.
Your Honor, we'll accommodate the 25th, one way or the other.
All right. So we'll see everyone.
Your Honor, I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right, 11 o'clock on the 25th.
Thank you.
All rise for the court, please.
I mean, fucking hell, Bev. Brennan, shut the fuck up. What are you going up there for? Look, why is she cancelling the whole hearings? Right, what did she say?
Seated, enjoy, cell phone off, put away.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
Oh, does that mean that she'll kick them off? I've never seen that before. Is she able to kick him off? Is that what she means? Yeah, I've got to go back and watch that, Robin. This is why I want to watch it again. So, because she's basically threatening, well, if this is true, then, you know, maybe Jackson won't be allowed in her court. Let's have a listen to what...
So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in
She's out of breath talking as well. She's mad.
the morning. You can tell me now if that is impossible for you.
She's a fucking drama queen as well.
And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13th, 2025. I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining.
That's a big difference, Brennan, between feds and the defense. Like, the way he said it initially was, in my opinion, a little bit dodgy. That doesn't sound as dodgy now, Brennan. You sly bugger, you.
So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
So that's different again. Do you mean, if this is what I was saying earlier on before the break, it's a little bit dodgy if this all happened and then, but now that's different. The defense did tell him all about this and stuff. So, and that's shoddy. That's shoddy. That he'd been caught in a lie there, and now he's trying to rectify it because now she's pissed. He caused her to be pissed, and he knows the defense can go back and go, what he fucking told you the other day, it's a lie. Oh, I hate shit like this. Hate shit like this. Hate it. Don't be corrupt. Like, how are we supposed to trust him moving forward when he's just as corrupt? I want a fair trial for Karen Reid. No, you fucking don't, you mouthful. And Bev, come on, stop being a crybaby. Why can't Alessi's there to do a motion and that he just wasted a whole day? He just wasted a whole day, prepped everything, now he's going to come back next week. All because fucking that fucking, what's his name? Not Addison, Brennan, lied and riled her up. And now she's pissed. Now she's put all the toys on the pram. Now we've got to wait another week now. Fucking hell. This trial's never going to take place if this is what's going to happen. But anyway, I don't know. It's a nightmare. Bullshit. That's what we call this in French. Bullshit. I hate it. Obviously, there's going to be tons of people out there that will cover this. I give a shout out to Brother Counsel. I think he's going to probably do a little snippet on this, because the one thing I don't understand is this: how can she chuck? Has she? Well, she definitely probably has the power to chuck, to take away Jackson and Little and all them, because they're all in the name of Yannetti. So is that a thing? I've never heard of that before. I've never heard of this happening before. So I don't know if it did come down to it, would she be able to revoke Jackson? Oh, LPH Picks, thank you so much for the PayPal and coffee. Thank you, my darling. LPH Picks, thank you so much to you for the PayPal. That will give me a coffee. Thank you very much, my darling. So did Gull do it? Okay, I don't know. I didn't cover that one. Okay. Because Jackson, Little, Alessi, I'm not sure about Alessi actually, Bedro, they will all come under Yannetti. He has to basically vouch for them. And would she have the balls to chuck him off? So Katie, what will happen there is it's going to be discussed next week. It's one of the motions going to be discussed next week. Now, that's when she'll get to hear his side. their side then, I should say. But when she said that, it sounded like, if this is true, Mr. Jackson, I'm going to check you off, Mrs. Jackson. So they already come under Yannetti. That's what I mean, though, Robin. As in, they're not like independent. So because they come under Yannetti, they're not lawyers in Boston, in Massachusetts. So, like, I would wonder if she could bar a Massachusetts attorney, whereas she's had to give permission for Jackson to be in that court, but she can revoke that because it's under Yannetti's name. Christina Rex tweet. Okay, Christina Rex. Let's have a look at Christina Rex then. Christina Rex. Judge Beverly Cannoni is unexpectedly suspending the rest of today's pre-trial motion hearing, the current retrial, after receiving information that causes her grave concerns. She says this is related to a federal investigation into the case. Grant Smith Ellis, it's over. Hang on, did she reply to something? Was that the one, yeah? So yeah. She won't get rid of Yannetti. I don't think she'll get rid of Yannetti, because I think it's Jackson that is dealing with this. So I think it would be Jackson then. I don't think she would get rid of Yannetti. I'm not sure how that would fit. I mean, if she got rid of Yannetti, then they're all gone. I mean, so then his trial would be suspended. Thank you, LPH, because picks. Because if she got rid of the defense, as she's not going to, not fully anyway, then Karen would have to start with new attorneys, which would then mean trial would be pushed on. Oh, people, I'm only speculating about this stuff. I don't actually know about this stuff. I'm just guessing. I'm going by what you guys are saying. He shows an email and no invoice between the two. Yeah, there's something, but again, I don't know, Terry. It's a case of something came up. The Commonwealth is saying that the defense have been shady about the ARCA work and the communication they had with them and stuff like that. But I think Brennan's actually been shady by saying the FBI informed him when actually I think Jackson informed him. So, I don't know how it all works. But she's suspended the hearing today. Back next week. I don't remember what day. 25th, 24th. I don't remember what day. I think it might be the 24th. Is it? But whatever day it is, we'll be back here at 9 o'clock, whatever it is, to cover it. But yeah, have a look. This is the one beneficial time to look at other creators. 25th. Thank you, Robin. I'm intrigued to hear what Brother Counsel has to say, because I like him because he does short recaps. So I like that. So about the trends and stuff, or how easy this is for Bev, or what does she mean about repercussions to the defense and the defense attorney. What she said that, didn't she? Let's listen to it one more time. Listen to this one more time, and then I'm going to leave you and get some dinner. Thank you, Gary. Right.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects.
Profound. Right. What's the definition of profound? Profound effects, meaning. What's the definition for that? If I can find one. Oh, now my internet's fucking playing up. profound effects. Meaning, right, hang on then, let me just do that here then. Collins Dictionary. What is meant by profound effect? Right, let's have a look. Deep. Deep. It has a deep or serious effect on the situation. Deep. Okay.
On this defense and defense counsel.
On this defense and defense counsel. So she said the defense in the case of having to move the trial forward, and defense counsel would be to get rid of them, all or some of them. But like Lady Dice then says, basically Spanky misrepresented the information she's actually referring to. Yes. Well, because that's what I mean. Before the break, I was like, oh, this could be trouble ahead. But now that he read it out and said Jackson gave him the fucking, it's like, well, what? That's a major difference. If this all happened with the FBI, yeah, that's why I was like, oh, this could be a bit iffy here. But Jackson's the one that cleared it. So I hope he gets reprimanded for being a sly prick. Anyway, that's enough for me. There's more commenters out there. There's I think maybe, but what you got to remember is I think he did it. I don't think he was. I don't think she would have challenged it. As in, he was just being shady. I think. I don't think he expected this. Trying to get the defense team excluded. Yeah. Got scared and had to correct himself very quickly. He had to correct himself very, very quickly. And you see Jackson and all them, they didn't miss a beat. They're like, yeah, we'll come back next week. I'd rather be here though. Like if you got something to hide, why be on Zoom? He's like, no, I'll be here because I've got nothing to hide. Space Coast. Thank you, Space Coast. Okay. Yeah, I think so. Powerhouses they are. We'll see. We'll see who comes back. As I say, I'm not worried anymore. Now that what got clarified, I was a little bit worried, I won't lie, before the break. But now I'm not. Not after hearing that. Unless there's more to it that we don't know. But yeah. So right. As I say, there's people, there's like fucking 200 people covering this case. So you've all got people you go to people to look at, and I'm sure some people will be able to dissect that a lot more. But just don't overthink it until we know a bit more. But I'm still interested to hear about the 10,000 to go, Dana. I'm still interested to hear about the defense and how easy it is for her to stop the defense and defense counsel and stuff. I'm still interested with that. So keep an eye on that. If you hear somebody covering it, good lawyer will probably cover it. I just want a snippet of it. I don't want to look at a stream for like 4 hours going through it. There you go, Lazy. On the same page, Lazy. What if they said anything? I was like, maybe. 10,000 to go. I've reached it. I'm 12,500 today, Dana. So let's go. Also remember, it's per week, not per day. So if you have a bad day today, remember tomorrow. Gary, see you tomorrow, buddy. Thanks for being here, Gary, and thanks for the gifted memberships. She can in mass, but it never happened. Yeah, I never heard of it happen. Robin said Gull did it, so I've never personally seen it happen. That's why I'm a bit shocked. Aidan makes a good point. Hang on, Aidan's tweeted something here. Judge Bev didn't flinch when she found out that Michael Proctor has known McAlbus or that inverted video was entered into evidence in the murder trial, but she sure clutched her pearls hard when Spanky told her that the defense spoke with the witnesses prior to testifying. Yeah. That's what, yeah. Right, everybody. How good I, Gary? You got this. Lola, thank you, my darling. Lovely to see you. And thank you for being. Also, just to clarify, I love this chat that we can all be respectful. Me and Lona have. I think me and Robin G, I think, have a different thought process in the trial. But I love it. I love speaking to people that have a little bit of a different take when it comes to the trial and tactics and stuff. It's good. It's healthy to be able to speak to people. So thank you, Lona, Robin G, everyone that contributes to your thoughts. TB gotta have something maybe. Thank you, Sarah. Lovely to see you. Thank you, my darling. Lovely to see you, my darling. Bye, Mexi. There you go. Thank you, and again, thank you for the PayPal LPH picks. Yeah, all in the court. No, but that's an important part of it. It's an important part of the trial. So I like to hear that in insight. Do you know what I mean? We can all agree and we can all disagree as well. That's what I like about this chat. Respectful until Aaron Hack comes here, obviously. So thank you, everybody. Take care. We'll be back with the Griffin trial tomorrow and see what happens. Paper Hank has did the date on it, so this email could have happened after the shady, Tim. I know. Thank you, my friend. Thank you. Respectfully, yes. And again, thank you for the coffees, Robin G. Bye, everyone. Bye to you all, and I'll see you. Let me get my outro. I'll see you tomorrow, 8:45 for Zoom time. Love you all, most of you anyway. Dana, love you. I'm joking. Resistance to Silence, 8:30 tonight. Pocket Rocket Dina's on. Go and watch it. You're gonna love it. 6:30 tonight. Sorry, I don't know if it's 8:30. 6:30 tonight. And with that, the outro. Love you. Take care. Ta-ra.
Pulls away, the tail light is well intact. All of that is not going to hold long.
Elvis has left the building. It's done. Over.